تعيشوا وتصلوا. احنا متأخرين شوية، فلو سمحتوا يلا. هناخد مع بعض النهارده الحلقة الثالثة من تعليم القبطي، وبعد كده هناخد الحلقة الثالثة من السلسلة اللي شغالين فيها. النهارده عندنا الوصية، فجست ممكن نقعد بسرعة عشان نشتغل شباب. معلش انا عارف ان انتوا اكيد وحشتوا بعض كلكم، انا عارف، بس عشان خاطري اقعدوا. اوكي، هسيب الميكروفون لعماد عشان ما اضيعش وقتكم.
بسم الله والابن والروح القدس احد امين. الاسبوع اللي فات خلصنا تاني حصه في اللغه القبطيه. النهارده ان شاء الله تالت حصه في اللغه القبطيه، وكنت هبتدي معاكم نلخص كل اللي قلناه قبل كده. ماشي، مش مهم القلم. قلنا اللغة القبطية فيها 32 حرف، 24 حرف من اللغة اليونانية القديمة، هي حروف سهلة ونطقها سهل، إلى جانب فقلنا 32 حرف، وكمان 24 منهم يوناني، واخر 7 حروف من اللغه القبطيه هم اللغه المصريه، متاخدين من اللغه المصريه القديمه. مين انت بتعرف تزهقني كل مره؟ انا عايز تديني عليه كورس كده لوحده. انا مش عارف، عايز حاجه ادوس عليها تقلب بس. بس كده، ربنا يخليك. تمام. اللغه القبطيه جت منين؟ زي ما انتم شايفين على ايدنا اليمين، اللغه المصريه القديمه واللغه الهيروغليفيه والديموتيقيه، كلها دي كانت لغات بتستخدم صوره عشان تعبر عن كلمه. وابتدت الكنيسه لما جت لقت الصور دي في بعضها ما يصحش ان احنا نستخدمه، وبعضها غير مناسب للاستخدام الكنسي، فغيروا الصور لحروف مبسطه، اشكال مبسطه الاول، فمرت بكذا ليفل من اللي هو الهيروغليفيه للديموتيقيه للهيراتيقيه، وصولا في الاخر للغه القبطيه اللي احنا عايزينها. او زي ما انتم شايفين كانت رسوم على الجدران في اللغه الفرعونيه. المرحله الاولى تحولت لرسومات مبسطه بدل الصور الكبيره. الرسومات المبسطه تحولت لحروف مشابهه ليها اللي متعلم عليها بالاحمر دي، مثلا حرف الشين او الشاي متاخد من سوره الشمعدان اللي كان في الفرعوني القديم. الفاي متاخد من سوره الحيه في اللغه الفرعونيه، وهكذا. فاللغه القبطيه هي ممتده من اللغه الفرعونيه للهيراتيقيه للديموتيقيه، وصولا للأبجدية اللي عبارة عن 32 حرف، 24 حرف من اليوناني. اليوناني طبعا أقدم من القبطي، هو اللي كان اللغة الموجودة في العالم، كانت لغة العظماء ولغة المتعلمين، والقبطي كان اللغة الدارجة في مصر. فالأبجدية اتحطت، خدت 24 حرف من اليوناني زي ما هي، وخدت من اللغة المصرية القديمة خدت من اللغة المصرية القديمة 7 حروف اللي هم آخر 7 حروف. برضه أفكركم إن إحنا مشينا على كل الحروف دي وخدنا أمثلة ليها. أنا مش هخش على الحروف تاني، إحنا قلناها مرتين، لكن عايزين نحاول نقرأ. اللي عايز بس أقوله هي دي الحروف ودي بشكل تاني أكتر تبسيط. مين يقدر يقول معنا الحروف؟ مين يقرب؟ ألفا تاني حرف، بيتا برافو يا أسامة، بعد كده غاما، دلتا، إي، سو ده رقم 6 على فكرة بس هو مش موجود في التشارت. يعني إي هنا حاطين زيتا على طول، حطوا انتوا عندكم سو، بعدين زيتا، إيه تاني؟ إيتا، ثيتا، يوتا، كابا، لولا، مي اللي هي الام في الانجليش، ني اللي هي الان في الانجليش او النون في العربي، اكسي، مي ني، اوكي، بعدين اكسي، او، بي اللي عامله زي البي بقى الانجليش دي رو، وبعدين تحتها ايه؟ سيما، طاف اللي هي تي، وبعدين الحرف بقى اللي بيحيرنا اللي هو الابسلون، بعدين فاي او فاي، خاي، ابسي، بعدين او تانية او لكن دي او، ماشي، او، شيما، فاي، خاي، هوري، جنجة، تشيما، تي. آخر 7 حروف هم اللي متاخدين لو لاحظتوا اللي هو لو عديتوا من تحت خالص، شاي، فاي، خاي، هوري، جنجة، تشيما، تي، اللي هم الحروف اللي بالازرق هم دول اللي متاخدين من اللغه المصريه القديمه. تمام، ده بتنسيق تاني. هنا بقى لما طلبتوا ان احنا نعمل، هخلي مينا ان شاء الله يبعتها لنا على الجروب. هنا معموله بالانجلش عشان المره اللي فاتت كنا بنتكلم بالانجلش، كان معانا ناس يعني للانجلش، فعملنا الليتر والنوت البرونسيشن بتاعته بالانجلش، واماكن البوزيشن اللي بيجي ويتنطق فيها بنفس النطق، بس دي انجلش يعني، ماشي. ده بقى بالعربي بتاعنا كده، مش عارف اكبر البتاع، مش مشكله، بس لا كويس. دي الحروف ونطقها بالعربي زي اللي احنا قلناه بالظبط دلوقتي، بس ده ان Arabic يعني. دي الفاولز او الحروف المتحركه في القبطي. قلنا في كام حرف متحرك؟ مين فاكر؟ 7 صح؟ قلنا 7: الالفا والايتا، الالفا والاي والايتا واليوتا والاو والاو، ماشي؟ الابسلون والاو، 7 حروف. الالفا الالفا زي ادم او ابراام، شايفين أبرام اللي هو إبراهيم، أو أدام، أو مكاريوس. الألفا نفسها متعلمة، الحرف متعلم بالأحمر. الإي إيفا اللي هي حواء، أو بافلي اللي هو بولس، بافلي اللي هو بولس. تمام. الإيتا نفس الحكاية زي إيمانويل، الحرف بالأحمر في النص. يوتا زي تيجي، أو زي دوميتيوس اللي هو دوماديوس اللي هو أخو ماكسيموس. دي الحروف المتحركة أو الفاولز. هنا بقى اللي عايزكم تقروا. احنا المرة اللي فاتت عملنا براكتس شوية، المرة دي أنا حطيت شرط كده من عندي. أحسن حاجة إن احنا عشان نتعلم القراية خد حرفين أو 3 حروف بالأكتر، ما تنطقش كل الكلمة مع بعضها. مين يقدر يقرا؟ شيري بيرفكت. وبعد شيري في ايه؟ ني، مش ني عشان ده ايه ماشي. وبعدين او لوحدهم، بعدين تي بارثينوس. برافو يا صافي. بعدين بعد تي بارثينوس تي اورو، تي لوحدها، اورو ملكة، تي اورو الملكة يعني. وبعدين امي الحقيقية. تي لوحدها لان تي دي علامة تعريف المفرد المؤنث. هي الكلمة اساسا اورو يعني ملك. لو حطيت قدامها أداة تعريف مذكر زي اب اورو، زي لحن اب اورو، بنقول ايه؟ ملك السلام. هنا بنقول تي اورو ملكة، الملكة. ماشي. تي اورو، بعدين امي حقيقية. بعدين مين يقرا بعد امي؟ ان الي ثني بيرفكت. واللي بعدها قلناها قبل كده زيها شيري تاني. وبعدين ابشوشو بيرفكت. انتي بن لوحدها يعني بتاعنا. جينوس اللي هو جنس. بن بتاعنا، الجنس بتاعنا. بعدين اري اجفو نان، سهله. بعد كده ان إمانويل. ودي معناها ايه بالعربي؟ السلام لك ايتها العذراء الملك الحقيقيه الحقانيه، السلام الفخر جنسنا، ولدت لنا عمانوئيل. نصعب عليكم شويه برضو. مين يقرا؟ شيري. بعد كده ثي ايه تصميسي بيرفكت. نون ام بي او اوي ني. ام بي او اوي ني اللي هو النور. ان طا اف مي، ان طا اف مي بخريستوس. هي دي اختصار بخريستوس. بعدين بن نوتي، بن لوحدها ونوتي لوحدها. بن يعني بتاعنا، نوتي يعني إله، يعني إله بتاعنا، إلهنا. بعدين تي بارثي إث أواب، ودي معناها Hail to the Holy Virgin who has brought forth unto us the true light Christ our God. سلامة النور الحقيقي المسيح إلهنا العذراء القديس. انا عارف ان انا طولت عن وقتي. ان شاء الله المره الجايه هناخد لو عرفنا نقرا كويس هناخد الضماير، وهناخد ادوات التعريف الاول والضماير، وبعدين ادوات الاشاره، وبعدين ان شاء الله على حسب استوعابنا ممكن ناخد الازمنه، الازمنه في اللغه القبطيه. لإلهنا كل مجد ودائم الى ابد امين.
سلام، ربنا يخليك. مريم.
Okay. So I'm gonna switch between English and Arabic. يعني هبدل واحدة كده، يعني لما هي تقول حاجة صعبة مثلا هبتدي ترجمها. بس أول حاجة, this is Audrey, who is my friend and more importantly to you, a probate attorney. And so we're gonna talk about wills and other documents that help you. يعني إيه التدريبات اللي like the preparation أو الحاجات اللي ممكن نعملها عشان نبقى جاهزين لو في حاجة حصلت بعد الشر أو في حد توفى، يبقى كل حاجاته وكل الwishes بتاعته تبقى يعني respected. كل لو حاجة مثلا medical، لو حاجة يعني ليها في الاسيتس او كمان هنتكلم على كذا حاجه مثلا التعامل مع البنوك يعني other types of accounts. والعربي ان شاء الله هيتحسن لما نكمل. ساعدوني زي المره اللي فاتت. Okay.
Hello, thank you for having me, and I hope I can answer a lot of the questions that you might have. All right, why estate planning matters. One of the most common things I hear people tell me is, I don't want the government to have my money. And so it's important that you have the ability to write down what it is that you want, and then with these wills, power of attorneys, advance directives, your wishes will be what is actually honored.
All I have to say about that is, you know, I work for the government, right?
Also, it's important to note that everything we say is our own opinion, not that of our employers.
Oh, yes. So you have absolutely no problem there. But regardless, yeah, نفس اللي أنا قلته المرة اللي فاتت. فأنا للي ما يعرفش، لما احنا بنتكلم على حاجة بالذات في الضرايب، لو حد عنده مشكلة أو حاجة معينة أو سؤال معين عاوز يسأله، يعني تعالوا اسألونا عن الموضوع ده. احنا بس بندي overview advice, general advice. See, that's the difference. Okay.
All right, so to explain what happens if you don't write down your wishes. So these are the things that you want to avoid. So if you die without a will in Texas, then you basically, or whoever's left has to prove who is the spouse, who's the children. It's a very long process. So it could take anywhere from a year to more just to complete the probate process and to access the funds that were in the estate.
All right. فإيه أهمية الوصية؟ إن كم حاجة زي ما قلنا، إن اللي أنت عاوزه هو اللي يحصل لو في وفاة. وتاني حاجة عن يعني الوقت الموضوع هياخده لو ما كانش في وصية وحد توفى والموضوع راح المحكمة اللي هو بيسموها probate court. اوكي. موضوع البروبيت ده ممكن ياخد اكتر من سنة، بس ان حد يعني يبقى عنده الابيلتي ان هو يحرك فلوس، ان هو يبيع عقارات، ان هو يتصرف في عربية. فالوقت ده والتوفير الوقت ده وتوفير اللي انت هتدفعه مثلا للمحامي عشان يعمل الشغل ده اللي هو هيقضي اكتر من سنة، هو ده يعني أهمية الوصية، ان انت توفر المشكلة دي اللي بتحصل. وغير ان انت كمان يعني يبقى الاسيتس او الحاجات اللي عندك تتوزع يعني الطريقة اللي انت عاوزها.
I was also just going to add real quick, because I forgot to mention it, the cost, if you don't have a will, if you haven't written it down, is going to cost more in probate. It's going to be cost effective to write the will now, establish these documents now, because it will cost your estate less in the long run. All right, so another question that I get asked a lot is the difference between community property and separate property, especially here in Texas. So especially if you're married, this is going to apply. Community property means whatever you earned together during the marriage. Now that also means what you do for your job is still considered community property because it happens during the marriage. Any joint accounts that are created during the marriage. Anything that happens before the marriage is considered separate property, as well as any gifts that are given just to you directly or anything that you inherit directly. So anything from parents or grandparents or aunts, uncles that they wrote in their will that they wanted you to have that is going to be your separate property.
ففي كل ولاية أو كذا ولاية بيفرقوا عن البروبرتي، التعامل مع العقارات وكذا نوع، وحتى الفلوس والبنوك وكذا نوع من الاسد. ايه تعاملها، يعني هتتقسم ازاي لو حد اتوفى. فالتقسيم ده هو مش بس لو حد اتوفى، هو يعني في كذا موقف ممكن في يعني يحصل ان انت محتاج تعرف ايه هو الكوميونتي بروبرتي وايه هو السيبريت. ف من الاخر هي بتبقى الحاجات اللي حد داخل مثلا الجواز بيها اوريدي بتاعته، او حاجه هو مثلا يعني gifted to them، حاجه بتاعته هو personally ممكن تفضل separate property. الكوميونتي property دي مثلا كل الدخل، كل الحاجات المشتركة اللي بنشتريها وبنعملها وبنجيبها وبندخلها لما نبقى متجوزين.
And so in a will, when you are writing what property you want to give to the person, you can only give away half of your community property. The other half automatically goes to the spouse under Texas law. But all of your separate property can go to whoever you want it to go to.
أيوة.
If it was bought during the marriage, it's community property. If it was bought before, then it's your own. Mm-hmm.
If you are married, so each one need to do his own will, or both can have the same will?
So the recommendation that I give is for each person to have their own separate will instead of having a joint one. If you do a joint one, when the first person passes away, then that will is going to probate, and some judges have argued that that will cannot be changed because one person has already died, so then whoever's remaining is not able to make any changes to the will. So it's safer to have two separate wills. They can look alike, they can say the same thing, but it's just easier if the two are separate.
فالسؤال كان هل احنا يبقى كل واحد عنده الوصية بتاعته او الاثنين مشتركين متجوزين يبقى عندهم وصية واحدة؟ الرد ان لا، هو اللي يستحسن ان كل واحد عنده وصية عشان لو حد توفى السرفايفنج سباوس، يعني الحد اللي بيفضل مش هيبقى عنده قدرة ان هو يغير اي حاجة في الوصية دي، اللي هي لو عملتوها يعني اتنين في وصية واحدة.
All right, so if you have a will, the spouse retains their half of the community property share, and then anything that you also have in your will, you designate what you want to go where. If you have a car that you want to go to a child, you can write that down. If you have certain jewelry pieces, you can write that down saying you want it to go to your daughter or granddaughter. So anything that, other than that 50% that's already given to the spouse, everything else can go to whoever you want it to go to. If you don't have a will, there are two tracks you see here, and there's actually a few more, but these are the more simplified ones. If you don't have a will, but you do have children, the spouse inherits all of the community property, so everything that was earned during the marriage, and 1/3 life estate of the separate property. And then the children will have the 2/3 of the separate property. If there's no children in the marriage, but there's no will, then the spouse inherits all of the property, 1/3 of the life estate of the community property, and then 1/3 of the separate, and then whoever the heirs are. So these are going to be potentially parents, siblings, nieces, nephews, or in some cases it's children as well, of the separate property.
حد عاوز يترجم لي كلمة heirs؟ الورثة. ميرسي. See, this is crowd translation. Okay, أنا عاوز أقول حاجة بس عن موضوع الورثة ده قبل ما نكمل. لما بنتكلم هنا من غير الوصية عن الجوز أو الجوزة أو الزوجة والchildren، okay، والعيال، يبقى ما بصوا العربي هيبقى متكسر. أنا قلت لكم.
A lot of legal terms.
زبط يعني رجعت لها ولا ما رجعتهاش؟ رجعت لها. ميرسي. Okay, I'm getting made fun of. You don't need a translation for that.
You switch language.
Yeah, there you go. Okay. الجوز والزوجة والولاد غير ان احنا نتكلم على الورثة. ليه؟ علشان من غير وصية بيحصل حاجة اسمها interstate succession. I'm just going to find the bottom pieces. فبيبقى يعني التوزيع بتاع الاسيتس بيمشي الأول للزوج أو الزوجة، وبعد كده للولاد، وبعد كده الورثة. شفتوا؟ شاطرين. وبعد كده الوصية من الآخر ممكن تحط أي حد، صح؟ يعني مش هتمشي بالتدريج، ومش لازم كمان يعني ممكن يعني أنت ما ينفعش تتصرف في الكوميونتي بروبرتي غير النص بتاعك، أوكي؟ بس ممكن تبقى أسهل إن أنت تعمل يعني تفرق بين ايه نوع البروبرتي وايه التقسيمه على الناس دي، غير ان هم بس يوصل لهم تلت او تلتين من الاستيك كلها، من المينا تركه اوكي، من التركه. خلاص اوكي. ايوه both spouses die together, what happens?
Then everything goes to the heirs. So to the heirs.
To the heirs.
Yeah. Which the heirs will include children in that instance as well. Mm-hmm. Yes. The first set of heirs, so the primary heirs, are going to be children. If it's not children, it's parents. If it's not parents, it's siblings. And if it's not siblings, it's going to be in-laws. Like that order? Oh, division. It'll be even, yes. Correct, yes. And then it'll be split between the children. Mhm. The children are part of the heirs. Correct, yes. Yes, children will get 100% if both parents die and they do have children, yes. They still get it, yes. Mhm. So yeah, so with the heirs, how they do it by ranking. So children are going to be the primary one. So if there is children, they get everything. If there's no children, then that's when they go to the parents. And then if there's no children, there's no parents, that's when it goes to the siblings. If there's no children, there's no parents, there's no siblings, goes to the in-laws.
Yeah, it's tiers. يعني حاجة مدرجة. I think هو ده اللي كان confusion.
No.
هنرد على ده. So okay, so we're going into like who would be the guardian of the children. So do you want to wait until we talk about guardianship?
Okay, so if there is no will, if you did not pick a guardian, then the state will decide who the closest relative will be.
That's also.
They're going to look at who is nearby and who is closest, like grandparents, aunts, uncles.
Relationship and geography. Nearby.
But you can pick who you want your children to live with, and so in a will, you can choose who the guardian is, and we've got a slide to explain that as well. Correct, yes. So what I tend to estimate, it can obviously differ. If you do not have a will, it's going to take probably a full year just for the courts to prove who the spouse is, who the children are, and it's going to take outside witnesses just to prove that there's no other spouse, child, so it's going to take a lot longer. With a will, you can probably get a hearing in the court 1 to 2 months, so it's much shorter of a time span.
مين قصدها ايه بان يبقى في hearing ونعرف مين الورثه من الاخر يعني الكورت هينفستيجيت مين هم الورثه الاول فلازم هتروح المحكمه مع محامي كذا مره عشان يبقى في witnesses ويقولوا مين هم الورثه. Do you have to specify what the assets are in the will?
It depends. It depends. If you are wanting certain things to go to certain individuals, then you will want to write it down. However, you can write a separate memorandum that attaches with the will. If you just want to say everything, all of my stuff goes to this person, you do not have to detail every single item. Yeah, if you write a will, everything will be included in there. You don't have to list everything out. So it's a catch-all that everything that you own will be included in that will. You can change a will as long as you're alive.
Unless you want to.
So the will, once you have it written, you get to keep it. You don't have to file it in the court, so you keep it either in a safe deposit box, within your home, somebody else's home, as long as you know or somebody knows where it's at. As long as it is signed by a notary and 2 witnesses, it is valid. There are certain legal language that you want in the will, just so that way it is self-proving and that the court's not going to fight it, basically.
يعني ليها صيغه من الاخر زي كده يعني زي توكيل almost نفس هتلاقي نفس الفورماليتي بتاع مثلا واكشلي احنا هنتكلم عن التوكيلات فممكن هتتكلم شويه عن ايه هو يعني ايه هي مش هتوريكوا language like we don't have specific language بس يعني هتكلم عن على كذا document وهم كلهم kind of are formal.
All right, so we've been talking about a will. It's a legal document that says to the beneficiaries, to the people that are left behind, and the judge what happens to your property, and especially if you have children under the age of 18, where they will go and who they will live with after you pass away. So it helps make sure that your wishes are followed, that your children are being raised by the people that you want to raise them, and that all of your items go where you want them to go.
لو حد عنده سؤال at some point you can ask me بس أنا مش
You want to wait for that one?
ده هنستنى عليه.
We have a slide for that.
أنا قصدي سؤال عن الترجمة مش سؤال عن فأنا هسكت شوية عشان هي إحنا قلنا إحنا الترمينولوجي كل الكلام احنا بنتكلم فيه هيبقى هو الفترة فمش هحاول إن أنا أترجم لكم حاجة أنتوا clearly فاهمين فلما حد بقى يعني يبقى عنده سؤال سألوني.
All right, so key functions of the will, again, property distribution, not just the homes or buildings, but anything that you own. Cars, vehicles, boats, jewelry, all kinds of things can go there. So you decide who gets that. If you just want to say, all of my stuff, I want it to go to my spouse, or all of my stuff, I want my kids to split it, you can do that, or you can specifically say, I want this house to go to this person, this car to go to this person. If you have children under 18, choosing who is going to take care of them. This is crucial because, again, God willing, we never have to worry about this, but it's important that we have this backup just in case, so that way our children are being raised by the people we want. And then the executor is the person who is going to make sure that the wishes that you've written down are actually done. So the executor is going to read your will, and once the judge approves it, if you say that you want the car to go to your son, the executor is going to make sure that your son gets the car. So they're going to follow whatever your will says. They cannot just do what they want. They cannot make the decisions. They're going to follow what the will says and make sure that it was done.
Fine. So the one thing يعني الحاجة الوحيدة هترجمها بس إن إحنا هنتكلم على موضوع الexecutor ده for a while وهنتكلم على ال guardianship so who the guardian is وهنتكلم على حد تاني اسمه trustee فأنا هقول لكم عن الاثنين دول الأول هم إيه وبعد كده الثالث لما تقدموا ممكن نتكلم فيه. فالexecutor ده هو المنفذ يعني هو بس حد أنت بتحطه مع الحاجات اللي انت حطها في الويل الاسيتس وايه التقسيمه اللي انت عاوزها هو بس هينفذ والمحكمه هتديله ورق ان هو يقدر ينفذ بيه يعني يقدر يتحرك يتصرف في الاسيتس والجارديان هو ده هي هتقول دلوقتي هو بيبقى احسن ان حد انت بيسكي من اخر حد تثقي فيه ويجي بتحطي اكتر من حد. I answered two questions. I'll tell you in a minute. And then a guardian يعني ده اللي بياخد باله من لما سألته مين اللي هياخد باله من العيال بالذات لما هم under 18 هيبقى الجارديان طبعا ده فرق من لما ما يبقاش في وصية اللي هو المحكمة هي اللي تعين. They were just asking what were you asking about an executor who you appoint and I said you should also have an alternate.
For all of these, a guardian and an executor, I highly recommend having multiple options. So you have your first choice, but just in case something happens, you want a second and potentially even a third choice. When my mom did her will, I think she has 5 alternates because she wanted to cover all of her bases if possible. All All right, so choosing an executor. So again, this is the one that's going to read your will and distribute everything the way that you say that you want it. So one of the things they're going to have to do is find all of your property. So if you already have a list that you provide to them, or if they're knowledgeable about what you own, then this will be fairly easy. But if it's somebody that maybe doesn't know you as well, or maybe doesn't know all of your personal business, they will need to know what property you own, what bank accounts you have, so that way they can collect all of that money, collect all that property, and be able to distribute it to spouse, kids, parents, whoever it is that you designate. They also will start the probate proceedings, so they will probably hire an attorney and go to court in order to get the will approved by the judge. Once it's approved by the judge, then the executor is going to be managing anything that you owe to somebody or somebody owes to you. Once all of that is sorted out, then they can distribute that property to the beneficiaries, to the kids, the spouse, parents, etc.
So I'm just going to bring back a question from before, right? Which is, I think Mina asked, like, where does the will stay? Like, who is it with? How does it get to the court? How does the process start?
So the will can be in your possession, wherever it is that you find it to be a safe place, whether it's a lock safe in your home or a safe deposit box. Having the will in a secure location, and then whenever you pass away, they will have to find the will. So usually whoever your executor is, let them know where you put it, so that way they can find it. Once they have that, then they will go and take it to the court whenever they file the initial probate proceedings. All right, again, if you have children under the age of 18, picking somebody to raise those children and care for them up until at least to the point they're 18. If you want to keep them longer, that's up to you. So this only takes effect if both parents pass away. So if only one spouse passes away, then the remaining spouse, the parent of the children, will retain custody of the children. And again, naming alternates, naming not just one option, but multiple in, again, the worst case scenario. We want to try to avoid any problems, and we don't want anybody else deciding who is going to raise the children. You want to retain that power, so having multiple beneficiaries, multiple guardians, just to be safe.
I'm going to add something that you and I talked about that maybe you don't want to say. No, but I'll say it in English and Arabic. But the idea for your alternates is that you want to pick people that are close to you and that you trust. But if you go on family vacation every year with the same group of people, maybe don't put just those people in your will, right? So you would put people who are close to you and who are a close part of your family, and maybe later down the list you put other people as well. Okay? As long as people are nodding, مش هترجم فلو حد من الآخر ما يبقوش معك في الطيارة بالظبط.
Okay, so this one only applies if you have children who are under the age of 23. So as you can probably imagine, even if you have an 18-year-old, if something happens and then they inherit a lot of money, an 18-year-old may not necessarily be, mature enough to handle those finances. So when you have somebody who's 23 or under, you can create a trust within the will. So it's not a separate one, it stays inside the will, and it only begins after somebody passes away. And it's only meant for those children 23 and under. All of the property and money that they inherit will go into the trust, and then whoever is in charge of the trust will give them the money as needed for college, for a car, for maintaining their lifestyle within reason, things like that. Once they turn 23, whatever is left over, they get to keep it.
Okay, يعني التراستي ده بتاع الحاجات المالية، okay؟ ده حد هتعينه بيسك عشان يدير الحاجات اللي هتتساب لأي حد تحت السن 23، صح؟ بس احنا ممكن انا هسيب لكم موضوع الترجمه ده ليك انتوا، بس لا انا عاوزه بس افرق بين حاجتين، صح؟ ان احنا قلنا في الوصي على الواد اللي هياخد باله منهم اللي هو الجارديان، غير الوصي على حد ماليه، فاهمين قصدي؟ عشان كده بنفرق الحاجتين. You got it. You know exactly.
It can be the same person as the guardian. So if you like who you chose to raise your kids and they're also good with money, then it can be the same person. But if you have someone who is very nurturing and kind to your kids, but they're not good with money, and then you have somebody else who is good at money, but they don't want to raise kids, you can have them separate. So they can be the same if you want, but they can also be separate. Yes, the executor is different. So the guardian is only taking care of the kid. Trustee is only taking care of the finances for the kids. And the executor is distributing all the property to all beneficiaries, whether they're children or not. For an executor, it doesn't matter. The trustee is for 23 and under, or under 23.
And the guardian's for 18.
Guardian is 18 and or under 18. Yes, it can. Mm-hmm.
All of these people can be heirs, right?
Except for a trustee can be one of the heirs if they're not 23 and under. So that would be a little more complicated, but yes. Well, you would put the trust in there if you have anybody who is 23 and under. So, yeah, the trustee is required if you have. So what I would do, like if somebody were to come to me wanting to write a will, if they have children who are under 23, I would put the trust and have them select a trustee. So that way we're not like missing out on the trust or missing out on appointing the trustee. So that's something that your attorney that you meet with to write the will, they will ask you the age of your children to make sure if you need to put a guardian, if you need to put a trust.
So I'm going to insert a question here. Can we make the generalization that when we leave things out the will, the court decides it? There you go. So
If you leave it out of the will, the court will decide for you.
يعني لو نسيت تحط حد او حد طلع سنه لسه ما كملش السن وما كانش في حد، هو المحكمة هي القرار.
So let's take this scenario where you have a married couple and they have 3 kids. One is 25, one is 22, one is 17. So in this scenario, they're going to need an executor, they're going to need a guardian, they're going to need a trustee. The executor is going to make sure that the property is distributed among those 3 children. The guardian is only going to worry about the 17-year-old. So they're going to make sure that that person is taken care of. The trustee is going to distribute the property to the 22-year-old and the 17-year-old. So the executor can just give the 25-year-old the money right then and there. But for the 22 and the 17-year-old, the trustee is going to give them the money as needed, and then once each of them turn 23, they can get the rest of their portion.
Yes, and we're simplifying, right? Like you have to handle the assets, you have to handle the house, you have to sell, like, yeah. كان في سؤال.
There is not an immediate need, but one of the things you have to consider and why a will would be important is if the spouses died together, because then that would be the case. It transfers to the other spouse, and then that other spouse will need a will to then give it to the next owner.
If it's community property, right?
if it's separate property and you have a will, or if you don't have a will, it's going to be split between 2/3 the heirs, 1/3 the spouse. All right, so here's another document. So this is outside of a will. So one of the things that I wanted to highlight is a will applies after somebody passes away. A medical power of attorney, a financial power of attorney, and an advance directive, which is what we're going to talk about now, those only apply when you are alive. Once you pass away, these documents no longer work for like who's going to make medical decisions or financial decisions.
Okay, yeah. So we're هنتكلم عن التوكيلات دلوقتي. Okay. فالفرق بين الوصية والتوكيلات إن التوكيلات أول لما حد يتوفى خلاص it doesn't apply. It expires automatically. صح؟ والوصية هي اللي بتابلاي بعديها. فدول documents in addition يعني زيادة عن أو غير الوصية.
So medical power of attorney means that if you are unconscious or incapacitated, or if someone has dementia, Alzheimer's, they're not in the right state of mind to be able to make sound medical decisions, this power of attorney, while you are able to make that decision now, you decide who will make that on your behalf. So if you write it now and then something happens 20 years down the line and you're not able to think clearly or you're unconscious, then the person you designated will be able to make those medical decisions on your behalf. So you want to make sure that this person is somebody that you trust to make these important decisions when you're not able to make them. If you are unconscious for however length of time, the medical power of attorney has the ability to make the medical decision for you. Once you are conscious, you regain the power to be able to make your own decisions. So it's only meant to be in the time period that you are not able to make it. It will be long-term for long-term memory illnesses, dementia, Alzheimer's, Parkinson's in some cases. That may be when a medical power of attorney is more long-term. A financial power of attorney is the same thing, but it's for finances. So again, if you're unconscious, you're not able to make the decision, you're diagnosed with dementia, Alzheimer's, then whoever you designate as the financial power of attorney will make those financial decisions. They will be able to manage the bank accounts or pay your bills or handle property matters. So that way, if you're not able to do it, someone is managing these finances. So that way, your finances are not, like bills are still being paid, they're not going unpaid, things like that. So again, you want to choose somebody that you trust to handle handle these financial decisions. Let's see. Yeah, so someone you trust who's also very good with money, who can manage these finances on your behalf. All right, and then we also have the advance directive. So this is you writing down what you want to happen if you are unconscious or not in the right state of mind, and the doctor has determined that you only have 6 months to live. And so the question that the advance directive will ask is, if you only have 6 months to live, according to what the doctor says, do you want to remain on life support or life-sustaining treatments, or do you want to be taken off of those life-sustaining treatments? You'll still be given medication to make you comfortable. It would just be, you wouldn't be stuck to a monitor. That's what the advance directive looks at. If you have both this and the medical power of attorney, the advance directive, doctors are going to follow this first, and then they're going to consult with the power of attorney. The power of attorney is probably going to be reading this advance directive as well. So the medical power of attorney does not have more power over what it is that you write on this advance directive.
فاهمين ده ايه؟ ده اللي هو المستشفى بقى. المستشفيات بيدوروا على ده اول حاجه لو حد بيوصل لحاله مش كويسه وفي يعني اي خطوره ان هو يتوفى، ده هو اللي بيسالوا عليه، وده انتوا اكيد بتشوفوه اصلا في ورق المستشفيات، فهو ده اللي بتتكلم عليه. ده زي انستراكشنز، زي كانك بتقول للمستشفى هي تعمل ايه. ده غير ان انت تدي لحد صح التوكيل ان هو يعني يتكلم عنك. ده هو اللي يحدد، وده هو يعني اللي لو انت اديت لحد التوكيل برضو اللي هو medical power of attorney ما ينفعش ان هو overcome ده. يعني ده هو اللي يحدد اوكي. واي حاجه اي قرار غير كده، اي قرار غير الحاجات اللي في الادفانس دايركتيف ممكن الحد اللي معاه توكيل الميديكال ممكن ياخد القرارات دي. بس ده الاول، يعني ده البرايمري ثينج that they look at. لو ده مش موجود والميديكال باور اتورني مش موجود, so basically what happens, no, not which one's more, what happens if you have neither an advance directive or a medical power of attorney?
If you don't have either one, then doctors will probably try to go to your spouse or children and try to come to some sort of resolution. But in some cases, doctors will err on the side of caution, and they will just keep somebody on life support because they don't want to be responsible if you didn't write down that you want to be taken off of that life support.
بالظبط. مش شخص، ده مش شخص، ده مش انت بتعين حد يتكلم عنك، ده يعني صح. غير التوكيلات اللي هم الميديكال والفاينانشال. So how do you get an advance directive in the hands of you?
Hire a lawyer is the easy answer. But yeah, so having, and sometimes if you go to the doctor, they will have one you can fill out. But if you want it more detailed, you want one written specifically for you, meeting with the attorney to have it drafted. And then once you have that, then you can usually file it with the hospital or with the doctor. So a lot of the hospitals around here have my chart, so you can upload it directly into my chart.
It's something where if you are like nearing or in hospice care or something, once you start getting admitted to hospitals, they ask you for it.
Yes. All right, here's my favorite one. So these are the payable on death and the transfer on death. So this is something, well, at least the payable on death accounts. This is something that you can do like tomorrow or Monday when the bank opens. So a POD. Okay, hold on.
Okay. So هنتكلم عن حاجتين دلوقتي غير الوصية وغير التوكيل. دي حاجات من غير لما يعني التي او دي ممكن ما تحتاج حد يعمله لك، بس حاجات انت ممكن تتصرف فيها بسرعة جدا وبتبقى كويسة. ليه؟ ان انت ممكن تحدد مين اللي هياخد الفلوس اللي في البنك مثلا مع البنك نفسه، وانت اللي تحدده وتروح بكرة تحدده. فهي تشرح شوية اكتر عن كده. والتي او دي ده اللي هو transfer on death deed، يعني هيبقى حاجة ازاي تدي مثلا اي عقارات لحد معين، ويبقى لما بعد حد يتوفى هيبقى خلاص البروبرتي دي بقت بتاعت الحد اللي انت حطيته في الديد. I gave some definitions while I was at it, but I didn't tell them how to do it. So that's fair.
All right, so a payable on death means that when you pass away, if you already have this designated at the bank, once the person dies and you submit the death certificate, then that money will automatically go to the beneficiary that you named. So if something, let's say that you go to the bank tomorrow when they open and you ask to put in the POD and you put your spouse on there. When something, hopefully, God willing, that doesn't happen soon, when something happens, then you take the death certificate to the bank, and whatever is in their account will automatically be transferred to the beneficiary. You do not have to go to probate if you have that done at the bank. So this is for bank accounts or any kind of, what do you call those? Investment accounts at these financial institutions. So you can go there, and some of them you can even do on the app, on the phone, but you can go there and ask to put a beneficiary or a POD on file, so that way it will automatically transfer to them once you submit the death certificate.
Yeah, so the same thing we do to a retirement account, we can do to a checking or savings account, for example.
Yes, even if it's a joint account, you can, yes. Yes, it's basically a beneficiary, but a lot of banks will call it a POD, a POD.
you're talking about
Oh,
community and separate property.
yeah,
So
that's-
how would you?
So if it's a joint account, what they will do, like especially if it's between spouses, they will already split it with the community property, and then whatever is that one person who designated the beneficiary, that's when it would go to the beneficiary. If you have the the joint account, if both are on there, then it automatically, you don't have to file anything. It just automatically goes to the next person. Okay, and then the TOD, the TOD, so this is a transfer on death. So this is going to be for physical property, like a house or something like that. So real estate. So it's going to operate the same way, except you can't just go to the bank for this one. You do have to have a deed drafted. And so you draft the deed that says that upon my death, this is who I want it to go to. And then it will automatically transfer to that person. And you can only transfer what portion of it you own. So if you and your spouse own it 50% each, you can only transfer your 50% to who it is that you're sending as the beneficiary. The important thing about these is they are really, really helpful in limiting how much probate you have to do, but they do not replace a will. Reason being is hopefully we cover all of our bases with these, but the will serves as a catch-all just in case there's anything that's missed. So sometimes we might have to create a bank account real quick, and we just have to do it. We create it, or we have to create a retirement account or investment account, and we forget to add a beneficiary. The will is there to catch it just in case you forget to put that beneficiary on there.
So can you do a transfer on death deed when you are still paying off and financing your home and there's a mortgage on it?
I think it depends.
So you actually, when you go and you get a mortgage, you do two different things. So this is property law. It's been a while. So you basically either you have a deed in your name to that house. So في عقد عليه اسمك من فوق وعليه الديسكربشن بتاع البيت ده والبيت ده بتاعك، وبعد كده البنك بيحط حاجة فوق ده علشان يضمن حقه في الفلوس. أو ساعات بيبقى في you can maybe if you remember اسم العقد ده ايه where مفيش أصلا a recorded deed that has just you على العقد. There's some sort of built-in interest to the bank already. So I think there would be a problem if there was some built-in interest to the bank. But if you have, even if there's a lien, a mortgage lien, that's so the أول حاجة أنا قلت عليها لما بيبقى في عقد بتاعك أنت وبس في mortgage lien على البيت مش مهم علشان mortgage lien will take priority. It will go into effect before transfer on death deed will go into effect.
So if you have a house that is worth $100,000, but there is a lien for $10,000, whoever you transfer it to with this beneficiary, they have to accept it with the lien on that property. I would go to an attorney on that one. So usually like property attorney or real estate attorney, some probate attorneys will also draft it.
عشان في صيغه برضو يعني هو من الاخر هي موضوع اوكي كل عقد حتى عقد البيت مثلا لو حد لاحظ وهو بيشتري بيت سالوك مثلا انت تحب لو حاجه حصلت لك مثلا البيت يروح للورثه ولا هيروح كله للزوج او في ساعات ممكن نغير صيغه الديد عشان يعني نغير مين اللي هو اللي هيورث. فالديد بالذات ليه صيغه معينه. Telling them the technicalities matter for deed. I was just talking about joint tenancy for a bit, which I probably should not have been doing. But and then دي حاجه ليها صيغه فممكن حد يكتب الديد ده الصيغه دي محامي او we were we're talking about what gets recorded, right? So this is one of those things that, and it gets, so this is one of those things that gets recorded in a county. فحد هيكتبه لك notarize it. It's a deed.
Yes,
Yes,
so
you're gonna
a
notarize
transfer
it, then
on
you're gonna
death
file it.
deed has to have a notary, so just the signature from yourself and the notary, and then you record it in the county that the property is located in. It's just extra security if you have both the transfer on death deed and the will. The will is going to catch anything extra that you may not have done the transfer on death deed for.
So دول كأنك بتنقي حاجة like you're taking each item and you're protecting it separately. وطبعا لو حد عنده like children الحاجات اللي احنا اتكلمنا عليها for children or anybody under 23 that might need a trustee or guardian does not apply outside the will, صح? And then what you said about الكاتشول. فدول حاجات فعلا مفيدة جدا ان انت لو عارف مثلا in bank account debt, this is something that you don't want stuck in probate. You just want it to immediately transfer, or the house, you want them to immediately have the house. It's very good for that. حاجة محددة. On the homes or any debt?
On the house, like the property?
Or any debt?
Yes, the debt does continue even after somebody passes away, except for student loans. Student loans do not. But any other debt does survive. Usually it's going to be the first priority in paying off debt is going to be like end of life, like hospital bills, medical bills, funeral arrangements, paying your probate attorneys, and then anything else, I think property, mortgages, and then at the bottom is going to be like credit card debts. So they're going to take last priority.
So yeah, so your executor or whoever the court appoints to be your executor in any case is going to work with the creditors and debtors, and I know that's on a later slide, but
You can do it for cars as well. Mm-hmm. You can do a transfer on death for the cars, for the vehicles. Yeah, the POD and the TOD, they are great for protecting each individual thing, like each individual bank account, each individual car, house. The will just makes sure that nothing that you might have missed has to go through intestate and has to be proven up with the heirs. So the will is like the basket that catches everything. Okay, trusts, because this question has come up. A trust, for the most part, is going to be if you have over, where's ours?
you want me to take care of this?
Oh, I got it. A trust is really if you have more than $13.99 million. That's when the trust is mainly going to apply.
عشان بس ده سؤال بيتصير كتير والناس بتطلع بالذات على on social media and talk about trusts, and so this is that number is a tax concept, right? And it's about the limit that you can transfer or that somebody can inherit or that the size of your estate can be before it is taxed, and that limit is 13.99 million per person. So if you're two people, it's actually 28 million. So.
That's what most people will use a trust for, is to protect any assets that go above and beyond that 13.99 million per person. The other way that you could use a trust is if you have somebody who is going to inherit under your will, but you don't trust them to manage the finances. So this would be somebody who is just financially unable to do it themselves. But even then, it's going to cost a lot to create a trust. There are usually easier and more affordable ways to take care of somebody who cannot manage the finances themselves. Yes, you can do a trust, but it's not recommended just because it's going to cost you more to do a trust than it's worth.
It's actually, I think for 2026 it's about to be 15 million. It changes every year. It's one of the things that gets adjusted with the tax code. So just like the deductions change, it changes. You want to talk about probate versus trusts and privacy?
Yeah, so a trust can protect some level of privacy, but there are also ways that you can do that with probate without having to do a trust, or doing the transfer on death deed, or doing the payable on death at the bank. That means you don't have to list those things in your will. So that's the main, there are alternatives to where you can still protect your privacy.
And a will and probate is pretty quick, so it's not really reasonable to spend all the money on a trust to save time or to protect your privacy or to save taxes, because none of those usually apply.
Because to create a trust, an attorney is going to charge you a lot of money to do. It's going to be cheaper to do a will, and you can still have these protections, especially if you do the bank account payable on death, the transfer on death deeds.
So you have to maintain a trust, right? It's not set it and forget it.
Yes, you have to maintain the trust. So one of the things that will happen is people will put their property in the trust, and then maybe they go buy a new car, and then they forget to put that car in the trust. And now that car has to go through the heirship proceedings to prove who the spouse is, who the kids are, and you're stuck in probate for like a year just trying to figure out who gets the car. So the trust, you have to maintain it throughout your life to add things into it, and it's also a pain to get stuff out of the trust to put it back in somebody's name.
You told me that yesterday. It's interesting.
The only reason the judge would not approve the will is if they find that the will was fraudulent. Like if it wasn't signed by a notary, it wasn't signed by two witnesses, that would be the only reason why the judge would not approve the will. So, and the judge cannot change the will, cannot change any of the provisions in it.
Yeah, مش بنقي. He doesn't pick and choose, right? Like it's either a valid will or not a valid will.
Yeah, exactly. This is the taxes slide. This is you.
Oh. Well, I think we talked about this a little bit. Do you want to talk about gift taxes? Maybe we don't. I mean, so اتكلمت على الفيدرال في Texas برضه ما فيش ولا estate أو inheritance tax. الكلمتين دول بيابلاي، يعني كل واحد بيابلاي في ناحية. يعني الاسtate اللي بتدفع من الشركة بتاعت الحد the deceased person والinheritance بتدفع الورثة هم اللي بيدفعوها بعد ما ياخدوا inheritance. ف ناحية يعني two sides of the same coin. هي هتبقى لو if it applies هتبقى apply kind of لنفس المبالغ، صح؟ لا إما المبالغ قبل ما تتفرق أو بعد ما تتفرق. بس هي مفيش في تكساس either one. وحاليا والفترة طويلة مفيش an estate tax for federal taxes other than if you pass لو عدينا ال 14 اللي هم يبقوا 15 مليون بعد شهرين. And there's something that we want to talk about that I'm forgetting. Oh, capital gains. Yes, okay. So the other thing that people ask is اللي هو, okay, my parents bought the house for $10 and now it's worth $100, okay? So do I have to pay taxes on the $90? That's capital gains, okay? So برضو نفس الرد. There's حاليا مش يعني this is not a state thing, this is a federal thing. And under federal tax laws you wouldn't really, there's no capital gains tax على inherited property. Yes, so
as long as it's under that 13.99 million.
So yeah, so yeah, an estate tax would basically هياخدوا من التركة هيشيلوا الفلوس الأول بتاعت الحكومة بعد كده هيفرقوا الباقي، بس it doesn't apply لغاية المبلغ الكبير جدا.
All right, so we created this graphic to kind of help, and so if everyone obviously is going to fall under that purple category. If you have children, you'll fall under the yellow and the purple. If you have property, you will also include the green. And if you have people who can't manage their own affairs due to, again, not being able to, like being incapacitated or unconscious, which could happen to anybody, that's going to fall in the blue category. So if you fall under multiple of these boxes, do all of them, all of the ones that are in those boxes. So again, everyone needs a will and testament. Doesn't matter how old you are, as long as you're 18 or older, you can write a will and sign a will. And then the payable on death and the transfer on death. Even if you are 18, you have probably a bank account or some sort of something that's you have your money in. So again, having that, and if you own property especially, making sure that you have a transfer on death. That's the very basic, what I recommend to everybody, to have those two things. If you have children, you absolutely need a will because you need to designate the guardian and potentially the trustee if you have kids under 23. If you have property, again, you want the will, so that way any property is going to be distributed the way that you want. Also having the payable on death for the bank accounts, the transfer on death deeds for property, and also having a financial power of attorney. That way, if for whatever reason you're not able to make those decisions regarding your property, somebody can make it for you. And then these other three are going to be the ones if you're unconscious. So who can make medical decisions for you if you can't? Who can make financial decisions if you can't? And if you are unconscious and unable to decide, if you want to remain on that life-sustaining treatment. It does not replace it. The POD and the TOD are going to take precedent. The will is just going to catch anything that you may not have had the POD or TOD for. So let's say that you have two bank accounts that you put the payable on death, but then you create the third one and you forget to add the beneficiary. The will take care of that third one, and the payable on death will take care of the first two. You can update the will. If you have the POD, though, and the transfer on death for everything, then you may decide that it's not worth updating the will. But you can update it within your lifetime as long as you are of sound mind to be able to sign it. So next steps. So if you are deciding that you need to do something or that you want to do something, the short answer is talk to a lawyer about what's going to work best for you. But write down your assets so that way whoever it is that will be taking care of this for probate purposes will know where to find these accounts. And write down the family members that you want to inherit something. So if you want to make sure that your parents are taken care of and so they have a certain amount, if you want to make sure your kids receive everything, write it down. Write down who you want to get something and what they will get. Let's see. Make care and financial decisions. So what is it that you would want to do if there's only 6 months left to live? The doctor says that you have an irreversible condition or a terminal illness. Do you want to remain on that life-sustaining treatment, or would you want to be taken off? And also, who's going to make those decisions if you're not able to, for medical and financial purposes? And then take care of the payable on death for the bank accounts. Again, you could literally do that tomorrow if you wanted to. Just whenever the bank is open, or you can do it in the app for some banks. Not all of them will do that, but some of them will. Adding that beneficiary on those accounts. And then meet with an attorney to discuss the other documents, the will, the transfer on death, and the medical power of attorney, financial power of attorney, and advance directive. For last will and testament, the 2 powers of attorney and the advance directive, I would estimate for one person, it could be anywhere from $600 to $1,000 to take care of all those documents. That does not include, though, the transfer on death deeds. That's probably going to be an additional fee. Yeah, those are about $200 or $300 each. So if you have however many properties you have, you will need a transfer on death for each one. So it would be about $200 to $300 per property, per transfer on death deed. Yes, you can. Yes. All you need when you go to the bank is just their name and their social security number. They will probably put it in a Uniform Transfer to Minors Act account. There is a particular type of account that they create for children under the age of 18. Yes, it will be distributed as they need it. So somebody will probably be appointed through the bank system and through who the guardian is to manage that account for them. They will take it from the estate. So they will take all the property that you own, the bank accounts, all the money, they'll put the value on it, and then they'll pull from that money. So if you are the executor for somebody, so somebody has passed away and they put you in charge, you do not have to pay the money from your own account. It's only paid from the estate account, what their estate was worth. And if you have like mortgage, loans, credit cards, the mortgage is going to come first in that scenario, and the credit card is going to be second. If the spouse is still alive and is paying on the loan, then that's going to take care of itself. But it's if both owners have passed away, then the estate is going to have to pay off that mortgage. Mm-hmm. No, if there's nothing left in the estate, then those credit card bills, there's nothing that they can do because there's no money left. So they can only pull from the estate money. Once all of that is gone, then there's nothing left, and so they can't come after you for that money.
مش بيروحوا يدوروا على عيال ويقولوا لهم تعالوا ادفعوا. في أي أسئلة ثانية؟ Look at us, we did so good on time. Thank you so much.
Thank you.
We really appreciate your time. Thank you for coming. We have been waiting for this lecture for 3 years ago. For 3 years, we've been waiting to find someone to give us this information. So we really, really appreciate your time. Thank you for coming in. That's a little thing from the meeting. Thank you so much. We finally have the information we've been looking for. So, yeah, let's do it. Let's do it. Don't worry. You sure? I'm trying to صدقني. المرة الجاية مفيش اجتماع. إن شاء الله نبقى في الكونفنشن. هنبتدي سلسلة جديدة إن شاء الله في ديسمبر هنعلن عنها إن شاء الله الأسبوع الجاي شغالين فيها يعني. Thank you منال على البليلة. Thank you مرسى على الفول وبطاطس. يعني you guys did great. Thank you so much. على فكرة الكومنتس كانت حلوة قوي يعني ناس عجبها يعني ناس اتبسطت فثانك يو. بنفكركم تاني اللي حابب يشارك في الأكل يقول لمريان هي مش من هنا النهارده. اللي حابب يشارك في الكورال احنا ان شاء الله هنبدا غالبا الاسبوع الجاي عشان حفله العيد. I think that's it. هتحرك امتى؟ انتوا تتحركوا individually. اللي بالنسبه للمؤتمر هيجي لكم ايميل ان شاء الله هنبعته بكره او يوم الاحد بكل الديتيلز بالديتيلد سكادجول بالاماكن بكل حاجه عشان تبقوا عارفين اللي بيحصل ايه. اي ثينك اول هو حسب ما مكتوب حاليا في الديسكريبشن بتاع المؤتمر لما تيجي تنزلي تحت خالص هتلاقي الجدول الموجود تقريبا هنبدا الساعه 12 اول محاضره تقريبا او الساعه 1 اللي تشيك ان الساعه 12. انا مش فاكر توصيل بالظبط بس احنا يعني he just send it to me right now so I'm gonna finish the email and send it tomorrow or Sunday. Okay. تعالوا بدري يوم الخميس ما تناموا يعني تتحركوا بدري عشان تتحركوا في قبل الحر عشان توصلوا بدري يعني. اوكي. حد عنده اي سؤال اي حاجه؟ اتفضلوا نصلي. Make us worship and pray, our Father who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth. forgive us our trespasses, we forgive us trespassing against us. Lead us not into temptation, deliver us from evil, and Christ, our Lord, for thine the kingdom, the power, the glory, forever. تعيش وتصل.